You have Patrick Findaro here, co-founder at Vetted Biz. Excited to have on Sam Levine, who's the director of the FTC's Bureau of Consumer Protection. Sam, thanks a lot for joining today.
It's great to be here.
Sam, maybe you could tell us a little bit about your prior work that you've done in your career and how it's kind of translated into your current work, and if there's some similarities, I guess, on the franchising side.
Sure, I'm happy to talk about that. My consumer protection career, my whole career has been in consumer protection. I was in law school in the depths of the financial crisis, and I was representing homeowners and tenants who were facing eviction as a result of foreclosure. And I really saw firsthand some of the abuses they were facing from their mortgage servicers, from their lenders, from others who I really thought were preying on them. And the best tool we had in those days to protect tenants, to protect homeowners, was consumer protection law. And after that experience, I went to work for the Illinois Attorney General, which at the time was negotiating a national mortgage settlement. But after that settlement was reached, I ended up turning my attention to higher education. And I was involved in civilly prosecuting for-profit colleges that were basically trapping students. They were luring students in with promises of, this is right after the Great Recession, you're going to make a lot of money. We can get you rich. The tuition's high, but it's easy to get a loan and you pay it off really quickly. And actually, so many people were graduating. Most of the people who enrolled were not even graduating. Those who did graduate often found that they made less money than they did before they were in school and suddenly had to take on a lot of debt. And from then on, I ended up going to the Federal Trade Commission. And now I look at a whole broad array of consumer protection issues in my current position, from predatory financial products, which is how I got started, but also issues like franchise, issues like privacy, issues like commercial surveillance, data security, national advertising, you name it, it's under the umbrella of the FTC.
What are some common tactics that bad players, whether it's a for-profit university or a franchisor that's promising some amazing business opportunity that's not going to happen, what are some tactics that they to use to rope consumers in?
Yeah, I mean, it's exactly as you said. We see this across the work of the FTC. Often we categorize this as business opportunities,
Yeah.
where I think there's always appeal, especially in this country. Work from home. You don't have to have and this surge during the pandemic. Work from home. You don't have to have a boss. You can just, passive income, sit around and earn a big living. That has a lot of appeal to people for
Yeah,
obvious
definitely.
reasons.
You invest like 100K, you get like
Yeah,
40K a year not doing anything. Sign me
yeah.
up.
And look, I'm very privileged to be happy in my job, at least most days. Many people are not happy in their jobs, and the prospect of
Yeah.
owning their own business and having their own source of income it has a lot of appeal. So what we often see is not only direct claims, and this is, again, it's not just in franchise. You see it in we've brought cases in multi-level marketing. We've brought cases with investment coaching. We've brought cases against for-profit colleges. Some of them will make direct claims that you're going to make a certain amount of money. Some of them will make more subtle claims. They'll have an image, they'll have an image of themselves on a yacht.
Yes.
They'll have an image of themselves next to a
Private jet.
Lexus. What's that?
Like a private jet.
Private
And this
jet.
this is what it's like to be a business owner. I've
This is
seen
what it's like
those.
to be a business owner. And they'll say, it's 12 hours a week. I mean, when I was doing for-profit schoolwork, it was even worse, because we would listen to these recorded phone calls with prospective students, and the recruiters would say to the prospects, I have to warn you. If you go to this school and graduate, you're going to make a lot of money, and all your friends are going to be jealous. Are you prepared for that?
Okay.
So it's really preying on people's insecurities. It's preying on people's desire to support their families. It's preying on people's desire to realize the American dream. And it's very problematic.
And it seems like these bad actors can come when someone's guard is off, where maybe they're having a bad time. It could be divorce, loss of work, whatever. And they're just looking for a savior. And that comes right at that moment. And I've seen a lot of people fall prey during that period of their life.
Yeah, that's exactly right. And these recruiters, I mean, it depends on the industry, but they use very sophisticated tactics to prey on people when they're vulnerable and try to push people to move very quickly, to sign on the dotted line, and then it's often too late. So that's exactly right.
And I listened to another podcast you're in, like this digital age, it's become harder because so many things can be personalized to that consumer. It can be hard to really catch, it's on an ad that we see in a big magazine. It's a ad that existed for not even a day and just for that very targeted segment.
Exactly right. I mean, I could decide that I just want to, let's say I read about a factory closing in Youngstown, Ohio. I could target people who are in Youngstown. I could target people who go to a certain church in Youngstown. I could target people. It's very easy to precisely profile the people who you want to target. We're long past the days of just buying an ad on TV and whoever watches it can call in. It's very easy and efficient to target people, and then you know exactly the situation they're in, and it makes it a lot easier to persuade them to pursue whatever business opportunity you're marketing.
Sam, what are some recent initiatives the FTC is conducting to protect franchisees and essentially ensure fairness in this industry?
Yes, we've been really active here. There are a number of initiatives, but maybe I'll start with the one that in some ways is most important. We really want to hear from franchisees directly. And one of the first things that our chair, Lena Khan, did, and actually a lot of this work predated her, but that we've done over the last couple of years, we made it easier for franchisees to file complaints. You go to reportfraud.ftc.gov. We've made it very easy and we've heard this from franchisees. We've made it very easy for franchisees to file complaints. We want to hear from franchisees. But that's not all we've done. We've also reminded the market that we have an enforcement role to play. We brought a lawsuit, for example, against Burgerine, which was accused, and we're still in litigation, so I'll be mindful of what I say here, accused of making some of the same false claims that we were talking about just a couple minutes ago. We have also put out a lot of guidance, both for businesses and franchisees. So, for example, we're currently publishing a franchise fundamentals series where we're giving franchisees advice on, slow down, read the paperwork, talk to a lawyer. We debunk some franchise myths, like you're going to be your own boss and make a lot of money right away. So we're really trying to get useful information in the hands of franchisees so that they go in eyes wide open if they want to pursue a franchise. And probably the biggest initiative we're pursuing is we've done a cross-agency request for information on a whole host of franchise practices, from fees to non-disparagement clauses to franchisees' ability to thrive within the franchise system and how terms might change. And so we're really taking a very broad look at the industry. And to aid that effort, we're really trying to hear as often as we can directly from franchisees. And the last thing I'll say just quickly, I'm in the consumer protection half of the agency. The other half of the agency does competition work, and they're very interested in this too. So we recently proposed changes to it's called the HSR form, which is a form that companies need to file, large companies need to file when they merge. But we're now proposing to require companies to provide specific information around franchising and how merged entities might implicate competition among franchise locations. So we're really taking a holistic look at this market to see, as you said, how we can make it more fair for people.
And it seems like this push of initiatives has already had an impact, especially bringing transparency, where you've released like over 2,000 public comments. I saw there were like 3,600. So that might be 2% of franchisees that left comments. And we used it for our research, identifying, good brands and bad brands and kind of some bad players, and hearing directly to the franchisees. And when there's a franchise system that 20 of the franchisees raise their hands to bad behavior, I don't see, hopefully that information can go to prospective franchisees so they don't fall into a system where there's already a lot of issues that need to be worked out between the franchisor and franchisee.
That's exactly right. And one of the things we always point out is the complaints we get are always the tip of the iceberg.
Yeah.
Most people don't complain. So if you're getting 20 complaints, I'm not describing any specific franchise, but if we're getting 20 complaints about a franchise, that probably means there are many hundreds probably of franchisees with similar experiences. The other point I'll make is that there are some unique problems in the franchise market that we have heard. These franchisees have told us that people don't feel comfortable filing complaints with us because of non-disparagement clauses in franchise agreements. So that's something we're exploring in our request for information.
I think, Sam, even forgetting the legal aspect, kind of the business relationship is going to turn sour. Like, if you have 3 locations and you wanted to open a fourth or fifth in adjacent markets and they found out you made a complaint or you raised your hand about what's going on, like good luck. You're kind of got to get out of the system or you're just going to freeze at the current level you're at.
That is absolutely a real concern. Now, it is also the case that there are other options for franchisees. Obviously, people need to comply with what's required of their franchise agreement. However, if people feel nervous, we do have sometimes people will file, sometimes associations of franchisees will file
Yeah.
complaints. So there are other vehicles to get information in front of us. But what we have heard from some franchisees is that these clauses do have a chilling effect, and that's one of the reasons we asked about it in our request for information that we issued, I believe, in March.
And Sam, how does the FTC collaborate with other law enforcement, state attorney general's offices? Is there much exchange of information and support?
There is, I can't talk about all of that publicly, but in
Sure.
the Burgerine matter, for example, is we're working closely with the Department of Justice, which is they've been a great partner to us in this work and in a lot of our work. We also have close relations with a lot of state regulators. Most franchise regulation happens at the state level. And some states like California and Maryland and others have been quite active. So we have a lot of contacts. There's a lot of deep expertise within state government agencies. So we really always look to partner with agencies, both state and federal, as we consider how to protect franchisees of this industry. And we're keeping our eyes open. We know that other jurisdictions outside this country have also looked into franchising issues, like Australia, Japan, Germany have done their own studies. They have different set of laws, different market conditions, but we always benefit from seeing what works and what doesn't work in other jurisdictions, and that informs our own approach as well.
That's a great point that you brought up because like in France, they can show more financial information and it's done in a way that I've heard there's less litigation and like the documents much like instead of like 300 pages, it's much more condensed. And it's more like, hey, this is what we found to be true based on interactions with these franchisees. It's less the franchisor putting everything out there, like disclose, 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 where they kind of, depending on the state, they can cover themselves for a lot of different actions, having a 300-page document instead of like a 20-page document.
Yeah, it's a balance, right? And it's one of the reasons we're always looking for what the best model is. On the one hand, it makes sense that you want franchisees to have as much information as possible. And what we say in our guidance is if you're going to go buy into a franchise, I should have said at the top, and I'll repeat, franchise can be a great vehicle for realizing the American dream, for becoming your own business owner. So I have no problem, and our agency has no problem at all with franchise system as such. But people should go in. I think people should go in eyes wide open. And we advise franchisees to retain counsel. With the benefit of counsel, they're going to look at all this information, and they should look at all of this information. But you're right. For people who are moving quickly, for people who are maybe a little overeager, for people who are maybe being misled by brokers or others, they might not read the whole document. And that presents a lot of problems. We know many Americans don't read these long disclosures, but the problem is franchise is a big investment. It involves risk, and if people want to pursue them, it's important they know what they're getting into.
Sam, does the FTC make any distinguish like who I see as like a true consumer is someone that it's their first business endeavor? Maybe they're not like an accredited investor by the SEC. They have a net worth under a mil. They're not making so much money. They're going into business, whether it's a business opportunity for the first time generally. And then you have more the sophisticated franchisee that they're definitely going to have corporate counsel. They already operate 20 restaurants. They're looking to get into another brand. And I think they know exactly what they're doing in most cases, but it's the consumers, the first time business owners that I see are really being taken advantage of in many cases.
Yeah, that's right. We certainly, whenever we bring a case, we have to think about what would a reasonable consumer do? How would a reasonable consumer interpret a claim? So, if we're bringing a case against a Gulfstream, I shouldn't use a specific example. If we're bringing a case against a private jet that appeals only to CEOs, that markets only to CEOs, we're going to be thinking about, are these, Fortune 500 CEOs going to be deceived? That can present some challenges. But for most cases, we think about, in the franchise case, we're thinking about who is the audience for these claims. And often the audience for franchise related claims are ordinary people. I mean, that's part of the appeal of the franchise system for good reason is that you don't need to be, when it works well, it means you don't need to be the son or daughter of a business mogul to start a business. And that's a good thing, but it also means that when we're looking at whether folks have been deceived, whether folks have been the victim of unfair practices, we're recognizing that these aren't all, Wharton MBAs. These are folks looking to provide for their families, looking to realize a middle class life, and that also can open them up to predation, and that's what we want to stop.
And there are a lot of players here, including some government incentives that allow people to invest in business offerings, business opportunities that haven't been proven. And they're able to secure SBA backed loans, 7A, 504 for some real estate type loans. How do you see that? And I guess parallels too to your prior life.
Well, we work with the SBA, and I know that they care a lot about the success of small businesses just as we do. I will say what I saw in the higher ed space is that because colleges knew that they could, if they were accredited, that they could get Title IV funding, that prospective students, regardless of their credit worthiness, could access a lot of money in loans and then pay the school. Schools had a very strong incentive to recruit as many students as possible, even if they weren't going to succeed at the school, because the school will be fine. They'll get the money, and the government will have to worry on the back end whether they're gonna pay it back. And again, I don't want to make specific observations about the
Sure.
franchise industry. What I'll say though is that when you have a model like that, you want to make sure that incentives are aligned so that the franchisor is actually invested in the success of the franchisee. The best franchises out there are invested in the success of their franchisees. That's what we want to see. That's the kind of market we want to see.
For sure. Yeah. Long-term success where the franchisees making money and or achieving whatever their dreams are
Right.
with business ownership. How do you see, and I don't know if you've dived into this, but talking to franchisees, and we've interviewed a few on our YouTube channel, where they get in a situation where it seems like by far the franchisee's in the right, but it goes to arbitration and they lose. Is that the end of the road? Is there other things franchisees can do if they lose in arbitration?
Well, it's going to depend on the scope of the arbitration of the arbitrator's decision. It's going to depend on what the franchise agreement said about the extent to which they're bound by arbitration. So it's hard to sort of answer that in the particular cases. What I will say generally is one reason it's so important to have federal enforcers, state enforcers. We're not party to these contracts. We're not bound by arbitration agreements. I will say I was in a case once with a for-profit college that made their students sign arbitration agreements and argued we couldn't
Too bad.
sue because the students had signed arbitration. That's nonsense. That's
Yeah.
nonsense. Setting aside my own views on arbitration clauses, there's no question that for state and federal enforcers, if there's deception, if there's unfairness, we have the ability to take action and take action in a federal court.
And would you say there's strength in numbers, whether it's through an association or having numerous franchisees raise a complaint?
Well, absolutely. But what we are really looking for is widespread practices. Again, that's not always what we have limited resources to bring cases. So we want to bring cases where we can have the most impact, where we're seeing the most harm. So when we're hearing from a lot of franchisees, when we're hearing from a lot of consumers about a problem, that's going to make it more likely we bring a case.
Could you share a recent success story? Maybe dive in a little bit of Burger Ream and those that aren't familiar with it, and how it positively affected basically prospective franchisees not getting into a system like that, as well as current franchisees.
Yeah, I mean, Burger Ream was, and again, it's in litigation, so I want to be careful,
Sure.
but Burger Ream was a major franchise that was marketing itself to franchisees. I think they called themselves a business in a box, according to our complaint. They said you don't need any business experience. And consumers were paying Burger Ream tens of thousands of dollars, sometimes $70,000 in franchise fees. And I'll add that the company, according to our complaint, was often targeting veterans with these claims. That did a lot of damage. What we allege in the complaint is that many of these franchisees ended up failing. We allege that many of the disclosures these franchisees received were not true. And, people lost their shirts, so to speak. So I think one of the messages that's sent is people need to go into these franchises eyes wide open. And B, I think the benefit it had is that I think we reminded the marketplace that we are fully prepared to enforce the franchise rule. We not only administer the franchise rule, but it's an enforcement tool. And that if companies are making misleading claims in their franchise disclosure document or otherwise violating the franchise rule, we're prepared to take them to court, and we're prepared to work with the Department of Justice. And when we do that, we're not only asking that the companies pay back what they took illegally, we can also ask a judge to impose civil penalties of $50,000 per violation, which can add up very quickly. So I think it's an important message that franchisors can face enforcement actions if they violate the law.
And those enforcement actions, I imagine they would be barred from ever having franchisees in the future, whether it's at that company or future ones?
Well, the cases in litigation, and we'll see
or
what
other
happens.
cases in general.
In cases in general, if its violations are serious, this week we announced a case not in the franchise context where we banned an individual from operating a business. If the violations are serious enough, we're going to ask a court to bar them from continuing in business
practice.
Yeah,
because that's what we've seen. A lot of times it's like the same actor that goes around, and like they're at a different company, and maybe it's not disclosed item 2, 3 with prior litigations or who the business managers are. So,
well, that's another good point. I mean, another lesson from Burger Eam, we didn't only sue the company, we sued I believe it was the CEO and the owner of the company. It's really important in cases that when individuals are involved in the wrongdoing, they be named as well, because we don't want a situation where the company is bound by an order, but then the people who actually broke the law can run and start another outfit.
Oh.
In those cases, we want individuals bound by court orders in addition to the firms.
Well, it's like what the SCC does, and you Google the name, and it's always at the top. So
exactly.
In effect, even if they're not legally disbarred from selling franchises, in effect, like people are going to know. Sam, I want to be mindful of your time. I don't know if there's a concluding thought, but for prospective franchisees or the franchising industry in general, but I really appreciate all that you do.
Well, no, I appreciate it too. And I guess my concluding thought is franchising can be a really good business model, but we've heard from franchisees about problems in this industry. And we're not the only agency, I think, that's heard from franchisees about problems in this industry. So we certainly encourage franchisees to visit ftc.gov, check out our series on franchise fundamentals. There's really good, easy to understand information on what to know going into a franchise. But we also encourage franchisors to remind themselves of their legal obligation, to remind their agents and their brokers of their legal obligations, to make sure that they're not misleading franchisees, that they're not engaging in the kind of predatory tactics that unfortunately we've seen across our work at the FTC. So this can be a good business model, but people need to follow the law in order for it to work.
Sam Levine, Director, Bureau of Consumer Protection at the FTC. Again, really appreciate you joining and speaking to our audience.
Great to be here. Thank you, Patrick.
Thanks, Sam.